My topic was noted on the program as historical child protection. Instead, I'm looking at a current case in which child protection clearly failed. Many of you may be aware that on Christmas Day, the bodies of two small girls were found in a ground floor apartment in Oak Bay, a municipality of Greater Victoria, British Columbia. Found with them was an injured man. The police had been called by the children's mother when their father failed to return them to her after his holiday access visit. The deaths of these little girls, their father was charged with second-degree murder, 2 counts of it immediately after being released from hospital, raised serious questions about the child welfare system in BC and elsewhere, and about child custody decisions in our family courts. This discussion that follows is based only on the written record of the custody decision in Cotton v. Barry, and does not consider other evidence that may have been available to both child welfare authorities and to the court in the hearing, for which I don't have the transcript yet. Nonetheless, even the written record, it provides extensive evidence that multiple red flags for the risk of lethality for both the mother and the children were ignored. Studies reveal in cases such as this of paternal filicide that in most cases mothers have repeatedly expressed fear about the future of their children, but they don't have evidence of abuse of the children themselves, so the fears are not validated or responded to by police, child welfare authorities, or the courts. Controlling behavior is a particularly important signal for filicide. It's a predictor of it, and courts must become much more adept at recognizing signs of coercive control, the means by which some abusive men, often without actually using a whole lot of daily violence, engage in malevolent conduct to dominate individual women by interweaving repeated physical abuse with 3 other equally important tactics: intimidation, isolation, and control. While the larger paper of which this is a part now goes into coercive control, filicide, all sorts of other theoretical issues, I'm just going to go straight to the case for the sake of brevity. So this case was heard in British Columbia's Supreme Court November 1st to 4th and November 14th, 2016 by Madam Justice Gray, who has since retired from the bench. At the hearing, Sarah Cotton, who was the mother of the soon-to-be mothered girls, was represented by Ms. B.E. Bate, but Andrew Cotton, the father of the children, self-represented. While he claimed that he had to do so because his money had all been spent on legal fees, at the time of the hearing, he was gainfully employed by BC Ferries in arrears for the entirety of his child support payments, over $50,000 by that point, and had both inherited money and won $100,000 in a lottery. So the non-payment was clearly a tactic of intimidation and control. His aggressive self-representation should in itself have been a sign of potential danger. We know that these things are linked. The court had to decide issues related to parenting time and authority, child support and division of assets, and Sarah Cotton explicitly asked the court to consider her many concerns about the father's parenting. So they met while they were both working at BC Ferries. They had 2 children, they purchased a home together, and she was a stay-at-home mother for the best majority, more than the majority of approximately 4 years that they cohabited, during which they had these children. In the summer of 2013, she first mentioned possible separation, and his response was to throw clothing at her, hitting her in the face with a belt. On September 11th, 2013, they argued about what the mother had done with the universal child care benefits. He had control over finances, and before he left for work, the father threw a drink at her in anger and intimidated her. He sent her emails throughout the day asking for details and returned home for lunch, and at the time when he returned, he said that he would blow up the house if he did not get a breakdown of what had happened to the funds. He looked very angry and crazed. The father didn't testify about either of these episodes, so he can maintain his silence while he stands in the court and interrogates her and scares the shit out of her. And he looked very angry and crazed. So he doesn't testify, and Madam Justice Gray accepted the mother's uncontradicted evidence. After lunch, she sent him a calm email with the details of what she had done with the money and stated, "I need to know that you'll have calmed down by the time you get home from work today. If you don't, I'll need to take action. I won't live like this anymore." On the night of September 13th, she was sleeping when he pulled the covers over her, jumped on her, and pinned her to the bed. She testified that she told him she would call the police, and then he got in his car and drove away. She immediately left. This is the end of their marriage. So she's doing everything right according to what we say women are supposed to do when they're violated. Again, he fails to testify about the events. This is the kind of premeditated and intimidating violence that is indicative of coercive control. We couldn't get a better textbook example. Her statement that she wouldn't live like this anymore suggests that while the pinning on the bed might have been a new tactic, coercion and control weren't new. Further, the threat to blow up the house constituted a direct threat to do harm not just to her, but also to the children who were in the house. Father's arrested, she gets a restraining order. In November, that restraining order is amended to allow him to see the children, and the limitation is short hours after school, 2 school nights, and parts of the days, both Saturday and Sunday. He continues with tactics of intimidation and control, repeatedly exposes the children to controlling behavior, belittles the mother's parenting skills, and uses the children as weapons to intimidate and harass her. He fails to respect custody agreements or pay child support, attempts to alienate them from their mother, and abducts them for short periods of time. He intervenes and uses his authority whenever possible, but doesn't pay and stonewalls the mother's own plans and desires for the children. So how does he do this? He refuses to sign passports. She selects a Montessori school for the kids, gets a nanny because she's gone back to work because he's not paying anything, and he refuses to pay for anything. He tells her that he won't pay for the nanny unless she provides timesheets. The older daughter starts spending overtime night with him. She tries to arrange a birthday party for the daughter. He says she can't come. He won't pay anymore because he's not getting the equity out of their house. They can't sell the house because he hasn't done his part to have the house problems in it remediated, so he's stalling everything. On the date of the birthday party, he demands that she meet him to take the child back at the police station. This is obviously a tactic of intimidation and fear. Then in August of 2015, the younger child starts spending nights with the father. This happens, how does this happen? In the presence of the girls, the father refuses to let the girls return to the mother unless she agrees that the younger one can spend overnight times with him. So he threatens abduction and actually holds them from her in order to enforce this. Then he starts with 1 night a week, and then he uses the same tactic again to force it to be 2 days a week. And shortly after the younger child starts having overnight access, she develops a urinary tract infection, and she says things to the mother which raise the concern that the father might have been touching her inappropriately. The nanny also testifies that the little girl had told her that her father hurt her vagina, and the older sister refuses to talk about it. So the Child and Family Services is contacted, the police conduct an investigation. He has supervised access for about 2 weeks, but then he gets unsupervised access again. But he refuses to take a parenting course or do anything to improve his interaction with children. This clearly should have been a red flag. Shortly thereafter, there's a soft spot on the little girl's head when she's with her mother. She takes her to the hospital. Another investigation of the father because this happens during his time of care. So physical problems in his care of the kids. Father also repeatedly denigrates the mother to the girls. The nanny testifies that the older daughter told her that she knew what the word selfish means. This means you only care about yourself. And father says, Mom's really selfish. She repeatedly tries to enroll the kids in activities, and he just stonewalls. He refuses to answer any of her emails. He also violates an agreement about taking the girls out of the jurisdiction, so is abducting them when they're not supposed to do that, takes them out of the jurisdiction and brings them, and she only finds out afterwards. In July of 2016, she gets legal representation, and she gets a court order that she's relieved of the requirement of personal service to the father. Why? Well, it doesn't say, but it suggests that it's because either he's evading service or he's harassing her when she serves him. Counsel also sends him a letter with a proposed change in the childcare schedule because the oldest girl's about to start school, and the mother's had all her access time basically during the week because she's now working from home trying to save money because he doesn't pay anything. He doesn't respond, so she, based on the failure to respond, she just says, okay, we're changing our childcare hours. So what does he do? Again, he pulls the same tactic of refusing to turn the children over. She actually threatens to call the police at the childcare center, and at that point he says, okay, I'll have them back to you at 6:30, but then he physically blocks her from giving the children a kiss goodbye and leaves in a huff. He also is silent and cold and difficult every time at drop-off and pick-up. They're ordered by the equivalent of the Children's Aid to provide a communication book with safety planning and saying where they're going, what he's doing. He just refuses to do it. And October of 2016, right before they're supposed to go to court, the younger daughter returns from her time with the father with a serious burn on her foot that hasn't been treated. The mother also says that the children, who by now are spending most of their weekend time with their father, are hungry, emotional, and in need of a bath when they return on Sundays. They haven't been properly cared for, and she doesn't even make any plans on Sunday evenings because she knows that the children won't be able to cope with it. It also is noted at this point that when the girls are with their father, the father sleeps, sometimes in a bed with one of the girls and sometimes on a pull-out sofa. Yeah. The nanny felt that over the previous 6 months to a year, the younger daughter had become more aggressive and the older daughter more reserved. The mother had paid for counseling for the girls and attended multiple sessions with them. She's doing everything she can. There's a trial in November of 2016. By this point, the father still hasn't paid any child support. And he says that he can't do this because he's waiting for the outcome of the trial to see. He doesn't think he'll owe any child support, and because he hasn't taken any parenting courses because he has a lot going on. So the decision is issued in May of 2017, so it's just barely over 6 months from the decision to the time of death. Madam Justice Gray dismissed the father's aggressive behavior around the time of separation and during some of the exchanges of the children as, these are direct quotations, transient and relatively minor, and asserted that it has not been directed at the children. She did admit that it may have affected their well-being because they've sometimes been present, but argued that this is not a case where family violence is a significant factor in determining parenting arrangements. Thus, was a dangerous, clearly controlling father allowed increased access to his children, whom he would later kill in an access visit. She admitted that the father has displayed poor judgment in dealing with the children. This has included saying negative things to the girls about the mother, the touching which led to the investigation, and his present arrangement of sometimes sleeping together with one of the girls. It can be hoped, on reflection, the father will recognize that it is a poor idea for him to say negative things about the mother and to sleep with the girls. She noted that the father has displayed poor judgment in dealing with the mother. That bad judgment has included failing to honor the safety plan about advance notice to the mother of trips out of Victoria, and about using the communication book and making exchanges of the children cold and uncomfortable. It also includes the father's failure to honor court orders and written agreements and failing to pay child support. But she did not consider at all the wider implications of these actions, whether or not they constituted evidence of coercive control or reflected any danger to the mother or children. She found the father to be a loving father who has much to offer his daughters. Vaginal infections. Anyway, it's in the best interest of the girls to have significant parenting time with the father. On the balance, I'm not persuaded that the father's displays of poor judgment regarding the children have reached the level that the children should be deprived of significant parenting time with him. She awarded greater parenting time to the mother, but the majority of it was during the week, with the father being granted 3 out of 4 weekend days out of each weekend period in a 2-week time period. So she gets all the work and he gets all the fun. So he gets rewarded for being a shitty dad. Holidays are being spent between the parties, which is why the children are with their father on Christmas Day 2017. Mother sought parental decision-making power, but the father contested and argued that he was willing to work to improve not only the volume, but also the quality of his communications with the mother. And he would like the parties to communicate almost daily by telephone. He suggested that the parties begin with 2 phone calls a week of 5 to 10 minutes, progressing to calls daily. In what was a clear understatement, counsel for the mother asserted that she was not sure it was realistic to hope that the parents could have daily phone calls. Obviously, this is a tactic of control. Madam Justice Gray found that the father has been strangely unresponsive to the mother concerning parenting matters. The evidence included many emails and texts between the parties. The mother's requests for responses from the father were consistently polite, brief, and informative. There was nothing provocative or insulting in the mother's communications. She admitted that the father's failure to focus on what is in the children's best interests regarding these activities and other questions is troubling and demonstrates poor judgment. It also demonstrates an inability to work cooperatively in parenting the girls. She found that the mother would have decision-making power if the parties are unable to agree, or if the father simply chooses not to respond within a reasonable time, which will usually be 48 hours. The father will have the right to apply to court to set aside any decision the mother has made if the court is satisfied that the decision is not in the best interests of the children. So she gives him a weapon to continue to harass her through ongoing court proceedings. Thank you. So evidence of tactics of coercive control are ignored completely. It's ignored completely in this decision. The decision denies overwhelming evidence that Andrew Barry repeatedly defied court orders and agreements, failed to consider the well-being of his children or to take steps to improve his parenting, and insulted, denigrated, and exerted control over his ex-partner through their children. Importantly, he also showed significant signs of psychological deterioration over the period where he was before the court and after the time of the trial, but nobody was watching. So in the summer of 2017, he left or lost his job at BC Ferries. He was served an eviction notice from his apartment for non-payment of rent, but refused to leave, so was in ongoing fight with his landlord. A neighbor described his apartment with things strewn all over the floor as chaos is an understatement. Another neighbor reported that his hydro had been turned off just 2 weeks before Christmas, and that the week immediately before Christmas, a neighbor had made a phone call to child protection authorities complaining about him. Cotton and Barry were in court for family litigation, probably her still trying to get money from him, as recently as the 23rd of November 2017, and the children died a month later. Desperate, angry, and ever-controlling, Andrew Barry imposed the most agonizing punishment possible on the ex-spouse who had refused to be dominated, who did everything right and who followed the law in everything she did. What did he do? He killed her children during the access time allowed by the court. Chloe and Aubrey Barry will not be the last children in Canada to die at the hands of their fathers. Until we recognize coercive control and provide adequate protection and support for women and children who are trapped in these relationships, this carnage will continue. These deaths are not inexplicable. They're completely understandable. They fall into the context of coercive control, and it's unconscionable that we allow them to continue.